Number 10, the people of the state of New York versus Albert Edward.
Good afternoon, Your Honors.
Good afternoon.
Lawrence Hausman for the defendant appellant Albert Edward. I'd like to reserve 2 minutes for rebuttal. And I would also like to start with the merits since we're in the middle of them, and then I'll get to the district attorney's alternative procedural argument. What I'd like to do is really focus the court's attention on Jamie D., because my concern is that the standard put forward by the people is way too broad, and it goes to some of the examples that Your Honors have posed. Because I think that if you consider it sufficient for a box cutter, which could otherwise be a lawful tool, to become a dangerous knife based on the fact that the possessor merely considers
Well, have they actually alleged dangerous knife here? Because I'm looking at the accusatory instrument, record A6, and they say the defendant possessed a dangerous and deadly instrument and weapon with intent to use it unlawfully against another. So in the actual accusatory part, there's actually no reference in this complaint to dangerous knife.
It's a fair point, Your Honor, that in this case they did use the charging language of dangerous instrument.
So they're going, the way I read this accusatory instrument, they're going with the second part of the statute.
To which you don't even trigger the presumption, but indulging the fact that the court may nonetheless, because of the penal law section that was charged, may nonetheless.
How is that the case? It's up to them to tell you what subdivision and what part of the statute they're using.
Right. Well, and I certainly don't think.
They could have superseded this, I suppose.
I certainly don't think there's any evidence of unlawful intent here. So if we treat this as a dangerous instrument.
So if it's in fact, let's say you're correct. Assume for a moment, because I'm really going to bring you to the second part of your argument. Let's say you're correct that in this particular instrument, they haven't made out the 26501 sub 2. But you have all these other charges here that are, you concede, correct?
Well, I don't concede. We haven't challenged
are
them.
facially sufficient.
I think I dropped a footnote saying that we haven't had the opportunity to contest them because we don't think it was properly
You
before the court.
certainly could have stood up at arraignment and moved to dismiss this entire instrument.
Right, but a facial
You
sufficiency.
certainly could have argued in your brief that the whole instrument is defective.
But we don't think the facial sufficiency of other charges save the facial sufficiency of the challenge charge, and that's because we think.
So let's say you're right that it's insufficient, but where I'm going is to their alternative argument that we should, because the whole point of Alejandro and all of this is the jurisdiction of the criminal court or whatever the local court is, but here the criminal court, to have that criminal defendant in front of it and subject to its adjudication, right?
Your Honor, I think there's a further protection, which is I think there's a protection that the charge of which you're convicted be facially sufficient and jurisdictionally sound. That's what People v. Harper, this court's own case, says, and that's a case that People v. Kaiser, that the people rely on, CFs. And the reason that People v. Kaiser was not a jurisdictional defect, it was because it was treated as a lesser included offense to which the defendant was pleading guilty. Now, and so the issue was analyzed under Article CPL 2-2020, which allows pleas to lessers that aren't even true lessers. Now, the disorderly
So
conduct
we have
charge,
fictional, right? We allow fictional. We allow constantly in hundreds of pleas a day in the criminal court. People plead to 240-20. That's not even alleged, and there's no disorderly conduct. So we do all of that.
Right.
So why isn't it, if we assume for the sake of argument that these other trespass charges are valid and sufficiently pled, why wouldn't we allow here him to plead to 26501, even if it's insufficient, to satisfy this entire accusatory instrument?
Because in Kaiser, those 240-20 pleas were analyzed under CPL 2-2020, and what this court says, that's not a when you plead to a lesser, a non-criminal offense, even if it doesn't literally comply with CPL 2-2020, that's a mere statutory violation. It's not a jurisdictional violation. that's different than a facial sufficiency challenge to a co-equal charged offense. And that's why I point, Your Honors, to People versus Harper. And this is what the Court of Appeals said in People versus Harper. You need subject matter jurisdiction over the crime of conviction. What happened in Harper was you had two valid charges, and then the court improperly, but with the consent of the defense, added two charges improperly. And the court said those convictions can't stand because there's no subject matter jurisdiction over those convictions. So it can't be that just because you have one valid accusatory charge.
So in other words, let's say you had this complaint, and they said, you know, Judge, I mean, in fact, the defense attorney said, I don't want him to plead to the weapons charge, but for whatever reason, you know, that's what happened. And let's say there were immigration concerns because there were particular charges here. Are you saying that they couldn't plead guilty to another misdemeanor and add a charge to resolve the charges with the consent of the prosecution and the defense?
Well, they could
You know, to avoid, you know, whether it's a crime of moral turpitude or whatever, you know, maybe the concern of the defense attorney allowing the particular charge.
They certainly could plead to a lesser under Kaiser, because once you're
Yeah, I'm not asking that. What about a co-equal misdemeanor? I mean, this is not like the felonies that
Right.
you have a constitutional prohibition.
Right.
So this
It's a little different than when you're talking about the facial sufficiency of the charged offense. If you're adding an offense and you're doing it under CPL 220, which is you're adding a lesser for plea purposes, even if it's not a lesser, because CPL 220 does recognize that sometimes you could have a co-equal offense for plea purposes. So if you're adding it for plea purposes, and there's no misunderstanding that you need notice as to the charge for which you're being convicted, because you're piggybacking off of a facial sufficiency charge, that's different than here, where if you're pleading guilty to the charged offense under Harper, you need subject matter jurisdiction over that charge. And you get subject matter jurisdiction over that charge by, in a plea case, by having that charge be facially sufficient. I think it's very important in you know, a lot of individuals.
So why doesn't the court have subject matter jurisdiction here with these trespass charges?
It would have subject matter jurisdiction over a trespass plea or over a lesser charge that's coming off of those trespass pleas. But the CPW
So
charge,
when they resolve in the criminal court, you know, somebody comes in, they're charged with, you know, selling, you know, something that's a Class D felony, and then they take that felony complaint and convert it to a misdemeanor complaint and add the charge of criminal facilitation for the purposes of disposition. Happens every day in Part N.
That's like Kaiser, Your Honor.
That's no good, or it is good?
that's okay, because again, like, as in Kaiser, there, the jurisdictional validity is coming from the greater charge, and the lesser is really an application of a statute, and so it may be a statutory
Criminal
violation.
facilitation isn't the lesser of any of those things.
Well,
That's my point.
right, but nor was disorderly conduct. But what Kaiser said is really that's just a violation of the 22020 statute. It's merely a statutory violation, but because it's still getting its jurisdictional strength from the greater charge, that's okay. Because 22020, which is rather flexible, and it's even been enhanced by the common law of this court beyond the literal terms of the statute, if you're pleading to a lesser, you look to the greater charge for the subject matter jurisdiction. But where you're talking about two co-equal charges that are both charged in the accusatory instrument, under Harper, they each have to have their own independent jurisdictional
Harper was a
validity.
trial, right? This is a
Harper
plea.
was a trial, but what Harper shares with this case is the notion that, and in Harper, the defendant consented to the submission of the charge, but what Harper stands for is that the crime of conviction still has to be supported jurisdictionally. And so what an interesting
They
point.
do make the point, the court makes the point in Harper, in the present case, there was a trial rather than the entry of a plea suggesting this is a rule for trial.
Well, I think what it does is it establishes that, you know, that that there's a difference between co-equal charges and lessers. Because in Ford, which is also a trial case, it was okay for the parties to agree to a lesser, even though it wasn't a true lesser, right? As long as the parties agreed to it, it was okay. But in Harper, they were co-equal, and that was a problem. They were co-equal, and one was jurisdictionally valid and one wasn't. That was a problem. And I think the same is true here, where you're talking about the charge to which you're pleading to has to be supported by subject matter jurisdiction. And just one
Well, I
important...
think that, just to quickly follow up, because your light is red, if I'm understanding Judge Garcia's question, his question is, okay, well, maybe that's the rule for a trial. Why should that rule apply with equal force to a plea?
I think the reason it should apply with equal force to a plea is because it's important to have subject matter jurisdiction over a charge. And one sort of side point that I like to make, this court has repeatedly...
Even if you can plead as something that doesn't even exist?
Well, there, it's understood by everyone that you're deriving jurisdiction from the charged offense. When that's not the case, there's an important systematic protection, which is that one of the few protections in a plea case, right, is the facial sufficiency of the charge to which you're pleading guilty, and you're going to have that conviction for the rest of your life. And so there aren't a lot of protections, and one that should exist and is good for both the defendant and the criminal justice system is to know that the crime that's going to be attached to you was at least supported by facts that established that crime occurred. I think that's an incredibly important safety valve in the system. It's one of the only protections that applies to the misdemeanor plea, and that's why I think, just like the jurisdictional issue that was held to be the applicable in Harper should apply to the plea context as well.
Thank you, Mr. Hausman.
Thank you.
Counsel?
May it please the court, my name is Cheryl Feldman. I'm here on behalf of the people.
Counsel, on this particular issue, I looked at our decisions in Hightower and Dumais, and they appear to implicitly reject your argument, and because actually, maybe it was, I think they implicitly rejected the argument that that the challenge that, because they reviewed the sufficiency of the challenged misdemeanor charge, even though there were unchallenged misdemeanor charges in the accusatory instrument. So why doesn't that indicate, no, we have to look at the equal charge that was being pled to, rather than say, okay, well, these other charges are fine, so we have jurisdiction?
The very simple answer to your question, Your Honor, is we never made that argument. The argument that I'm making now, I have no idea why. Had they made that argument, the court would have considered it. It wasn't made. The argument that was made was that automatically, regardless of whether there's one count, multi-counts, a defendant automatically forfeits this claim when he pleads guilty. And that's not the rule that we're asking for here.
So then, does the court have to look every time a plea to an equal charge is made, look to make sure that there's the sufficiency of some other charge?
What you have to make sure of is that the court had jurisdiction over the prosecution of this case and over the defendant. And by not challenging the trespass charges, the defendant, in fact, conceded that the court had jurisdiction over the prosecution of this case, and therefore, the statute allows, it's not a jurisdictional defect. The statute allows the defendant to plead guilty to one charge to cover the others. And as Judge Feinman...
Where does the statute say you can plead guilty to an equal charge, though?
Oh, yeah, it's, okay. The pleading statutes, which is, unfortunately, I don't,
Well,
wish I had it right in front of me. There's a statute that says that it lists the permissible pleas that a person can take. And in that statute, it says that you may plead guilty to one count to cover the other counts, which is exactly what this defendant did. What it says in that same statute is that you can't plead guilty to a lesser crime unless it's a real lesser included offense. And that's what happened in Kaiser. That was the challenge in Kaiser. They said, this isn't an official lesser included offense, and there's absolutely no facts in this complaint that support the charge of disorderly conduct. So the court did not have jurisdiction to take that plea. It's a jurisdictional defect. And Kaiser said, no, wrong. Jurisdiction was obtained in the charges that you're not challenging, so that you forfeit that claim that the charge that you pled guilty to was not sufficiently pled in the complaint. This is identical. It's really identical to Kaiser. Kaiser doesn't say only if you're pleading to a lesser crime, because as Judge Feynman also pointed out, there's many reasons why a defendant would prefer to plead to one crime rather than another.
Can I just ask, are you making a distinction between personal and subject matter jurisdiction, or
No.
that doesn't matter here? Or,
I'm-
well, personally, you can waive subject matter, you generally can't, so I'm just trying to understand
they
what
had-
your argument is.
No, my argument is that they had jurisdiction over the prosecution of the defendant being in a building, trespassing in a dwelling with a gravity knife in his pocket that he admittedly intended to use as a
This
weapon.
one was a box cutter, actually.
I'm sorry?
This one, I think, is a box cutter.
Is that what I said? No, I didn't say
No,
that.
you said gravity
Said
knife.
Oh,
gravity
I'm
knife.
sorry. I called gravity knife.
Yeah,
Yeah,
but anyway, I
box
didn't mean to
cutter.
the.
Whole other animal.
Yeah, I'm sorry. No, that he admitted, I'm not going to use this to cut boxes. I'm carrying it on the train for protection. He was carrying it to use as a weapon. So it's all one transaction, and to cover the prosecution of that entire
Does that make a
transaction.
difference? What if it wasn't the same transaction? What if the trespass took place on a completely other day?
Well, then it wouldn't be joinable. It wouldn't be in the same complaint. I mean,
But your
it was properly joined in this complaint because it was all part of one transaction. Francis says what you need is time and place, and victim if that applies, which it doesn't
But
here.
your argument is regarding jurisdiction over this person's violation based on the charge, right? It's that charge, the count, that you're
Yeah.
talking about?
Yeah, and in fact, I mean, it would be almost insane to think
So your position is that's waivable?
that, yes.
Jurisdiction is
It's
waivable.
forfeited by his guilty plea is my position. Just like in Kaiser, it's forfeited. He can't raise the sufficiency of that particular count because he forfeited when he chose to plead guilty. If he didn't choose to plead guilty, then, and he actually raised this below, I'm saying you can't raise this for the first time on appeal. If he actually raised it below and didn't jump on
Well,
getting the
so
10
what would
days-
have happened? Let's say he didn't jump on the 10 days, and he said, so would he move to dismiss the 26501? And a couple of things could have happened, right? The judge could have said, yep, I'm striking that, and now we only have 3 charges left.
Well, the
Or
judge
the judge could have
shouldn't do that.
said, make that motion in writing, and I'll think about it. Or you're right, but I'm going to give the people time to supersede. All of those things could have happened at the arraignment or at a subsequent appearance in the all-purpose part.
Exactly.
Right.
Or we could file a
But-
supporting
So
deposition
my
with extra
question,
facts.
or you could have cured it with a supporting deposition. But I just want to be clear about one thing, going back to, you're not claiming here that this was a dangerous knife. You're saying it was a dangerous instrument?
No, well, a dangerous knife is a dangerous instrument, under
And
statute.
just, because the accusatory part, the first paragraph of this particular complaint.
Correct.
I know what the statute says,
Right.
but the question is how you wrote it in this particular, whether there's a drafting error that made an ECAB. You may be stuck with that.
Well, I don't think that we're stuck with it, because if you look at the actual statute, 265, it says, or other dangerous instruments. So the fact is that a dangerous knife is a dangerous instrument.
Okay, but isn't, maybe I've misunderstood.
Sure.
Isn't the people's position that if it's a dangerous knife, the presumption is it's with intent to use, but if you're charging as a dangerous instrument, you have to have some other assertion in the charge to give you a factual basis for
Our
the intent?
position is that a dangerous knife is a dangerous instrument, And if, in fact,
Well,
you
everything
have
that's
that...
listed there would be a dangerous instrument.
I'm sorry?
Everything that's listed there, a dagger's a danger, I mean, isn't that the point?
Correct.
Okay,
Yeah.
but that's not what, I thought the people's argument was, as I think Judge Fahey, unless I misunderstood him, was clarifying in the prior case, that if you establish it's a dangerous knife,
Right.
the presumption is it's for the intent to use unlawfully.
Absolutely.
But if you charge it as a dangerous instrument, you have to have some other factual assertion to establish or to get reasonable cause for the intent to use the same unlawfully. Am I
Language is,
misunderstanding you?
Or other dangerous instrument.
Yes.
Our position is,
Yes.
this is a dangerous knife. This is dangerous. He admits it's a utility knife. And the defendant says, that's what a box cutter is, in effect, a utility knife. There's no question that he had notice of what we were talking about here. We're talking about a utility knife.
All right,
That's a dangerous knife.
if your claim is that it's a dangerous knife,
Yeah.
what do I do with the fact that the words dangerous knife don't appear in this complaint?
I don't think that matters. I honestly don't think that matters. He has notice.
The presumption in 265-15-4, when it discusses an instrument, requires the instrument be designed, made, or adapted for use primarily as a weapon, which is not, that doesn't attach to a dangerous knife.
Absolutely not. But I'm saying that the fact that we left the word dangerous knife out of the accusatory instrument doesn't mean that we didn't plead that the defendant had a dangerous knife. We said that he had a box cutter. A box cutter is a utility knife.
I don't remember the exact section, is it 100.40 that tells you what you have to have in the complaint? And you have to have two parts. You have to
Right.
have the accusatory part, that lays
Right.
out the particular statute, and you have to have the factual portion. And so I guess what I'm focusing you on now is if there's a defect in the first part, the accusatory part, what's the consequence of that?
Could have been cured.
I don't have any problem saying that it's curable, but you didn't cure it, and...
Well, we didn't cure it because he pled guilty at arraignments.
Okay.
We were deprived of the
But
opportunity.
so the question is that something that under Alejandro and all the cases that come after, that is, makes it defective and a loss of jurisdiction?
No, there was jurisdiction in this
Because of your
case.
Kaiser argument?
Absolutely.
Okay. So what is the remedy if I don't, we don't agree with you that, we can overlook this omission in the accusatory part? It's just, yeah, defendant, you're right, but it's a Pyrrhic victory because we have jurisdiction and Kaiser applies.
Absolutely. My position is that under forfeiture rules, under Kaiser, it didn't matter. In Kaiser, there was no facts. Disorderly conduct was not charged at all. There was zero facts supporting the charge of disorderly conduct.
And from
So
a systemic point of view, this is
exactly.
what happens every
it
day.
happens every day. And the fact of the matter is
course,
that
that doesn't
the
always make it
defendant could go
right.
to trial.
Yeah, my concern is that if the statute doesn't permit it, are we encouraging courts to
No,
accept
the
pleas
sta-
that are not permissible
What,
under the statute?
no, the statute permits it. The statute permits you to plead guilty to any charge that's in the complaint.
Can I
to
just-
cover the others.
I know you're out of time, but just one step back, just to clarify in
Sure.
my own mind. The defendant's argument is you're saying, and your jurisdictional argument is that the court didn't have jurisdiction, or that are they saying that the court didn't have jurisdiction, or are you saying that once they waived, or once they pled, that jurisdiction was gone?
What jurisdiction? I'm sorry, Your Honor, I'm not
All right,
understanding your
all right.
question.
My question is the jurisdictional argument.
Yes.
Did we lose jurisdiction over this case ever?
Never.
All right, so we have
And that's
jurisdiction.
what-
All right, so it's non-waivable, that's the way it's always been, and it always is all the way through, right?
What Kaiser says is that once jurisdiction over the prosecution of the defendant is established, it's not subsequently abrogated by a supposed pleading defect in the charge that he pled guilty to. It said, you don't have to look at the
Let me
accusatory
just,
instrument.
whoa, slow down.
Yeah.
So, but if the instrument upon which you're being charged is jurisdictionally defective, then there's no jurisdiction.
But it's not jurisdictionally defective.
I understand your argument, but it doesn't erase the fact that we have to address a jurisdictional argument, right?
Absolutely you do. And in fact, just to address counsel's question about how you're not allowed to, you have to. In fact, in Casey, if you look at Casey, the same thing that happened here. In Casey, the appellate term said, well, it was a challenge to an accusatory instrument on a supposed hearsay defect. And the appellate term said, well, no, he waived prosecution by information. And this court said, no, we disagree with that. We're going to decide it on different grounds. And the grounds are that hearsay is not a jurisdictional defect, and so the defendant has to raise it below.
The sufficiency of the instrument initially was that's an entirely different matter.
Yeah, this court always has to have jurisdiction to consider a claim. Our claim is that this court doesn't, because he forfeited this claim by his plea. So you have to reach that first before you can even consider.
Either we have jurisdiction or we don't. And it doesn't seem to me like and even though he pleads, if there's a defect in the instrument, it's non-waivable jurisdictionally. You're saying it's waivable.
I'm saying there's no jurisdictional defect in this complaint. If you look at Kaiser, that's what Kaiser says. It's not a jurisdictional defect.
I get that. I'm all right with that. I understand what you're saying.
Thank you, counsel. Counsel?
Okay.
I'm sorry.
If I could make a few points on the Kaiser-Harper procedural question. One is that I'd like to read this language from Kaiser, which says, in the circumstances alleged here, there was no statutory noncompliance rising to the level of a jurisdictional defect, CF Harper, thwarting defendant's plea to a lesser crime not included in the accusatory instrument, and it's earlier just mentioned that it's a non-criminal offense. So I think the notion that once you have a valid charge in an accusatory instrument, like all bets are off, is not true. This was a narrow decision that you have a valid charge, you're pleading to a lesser, so that's different than pleading to a co-equal charge offense. You're pleading to a non-criminal offense, and under those circumstances, the sort of technical violation of the plea down statute 22020 wasn't a defect that rises to the level of a jurisdictional violation. And I think that sort of more narrow reading of Kaiser is consistent with this court's history of treating these cases with multi-count accusatory instruments, like Judge Stein was mentioning, Hightower, Dumais, Dryden, Kalin, where there are several counts, but there's a count to which the defendant pleads guilty, and that's the one that's challenged on appeal. And historically, that's the count that this court has addressed. Now,
I take it you disagree with her position that the jurisdiction is waivable.
that's correct. I think that either it's a jurisdictional issue.
Forfeited, excuse me.
Right.
Using her terminology, forfeited.
Either it's a jurisdictional issue or it's not. In Kaiser, it wasn't, because it was really viewed as a de minimis violation of this lesser plea statute, and they took into account the fact that it was a lesser plea, it was a non-criminal disposition. This is different. This is like Hightower. This is like Dumais.
So let's assume that you're right, and so now we have to make the decision as to whether the same analysis should apply, because we've never directly addressed it, maybe, to this situation where we have co-equal charges. Right. What are the reasons why we shouldn't apply the same analysis as we did in Kaiser?
I think the reasons are because of the systemic reasons I pointed to. Because when a defendant thinks he's pleading to a charge that's jurisdictionally valid, the integrity of the system and the fairness of the defendant require that charge be supported by facts, so that conviction, which the defendant is going to live with.
The defendant's charged with burglar's tools and, also auto stripping and, some other charge. It turns out that third charge, possession of a controlled substance, all right? And he says to the judge, I don't want to plead to the burglar's tools, and I don't want to plead to the auto stripping, because after all, if I get another auto stripping, it's going to be a felony the next time around. But it turns out, you know, the 220.03 that he pleads guilty to was insufficient. Why isn't you know, from a systemic point of view, it's a negotiated plea, the defendant's getting some benefit there. Why isn't that okay?
Well, because I think the larger systemic concerns that I pointed to outweigh the fact that in specific cases, you might say, oh, well, you know, maybe the defense, you know, maybe everyone was fine in that situation. I think there's a systemic importance to knowing that, you know, hundreds of thousands of people are prosecuted, right, every year in New York City. They go, many of them at arraignment are making the choice between pleading guilty to the charged offense or spending several months in jail. And I think there's an important safety valve integrity piece of the facial sufficiency requirement that says that, like, that ensures that overall the crime to which we're pleading guilty you know, is jurisdictionally valid, supported by facially sufficient facts. I think it's consistent with Hightower and Dumais in this court's, the way this court has treated multi-count accusatory instruments is to say that the count to which you plead guilty, you know, with the exception of lessers, which really are piggybacking jurisdictionally off of the charged offense, that is important to the integrity of the system, that you apply the Harper analysis, which is that if it's you know, for a charged offense that you're going to be convicted of, that that offense be jurisdictionally valid.
Your light is off, so I just have a quick question. Are you in agreement with this interpretation that 265.01 provision 2, if they've charged that it's a dangerous knife, that there's a presumption of the intent that applies?
So if they had charged it as a dangerous knife, and if this box cutter qualified it as a dangerous knife, the presumption would at least theoretically apply from the outset. We argue, and I think that the presumption is irrational in this case, because you're joining possession of a lawful object with a lawful intent, and we think it's irrational to apply that presumption. We also, I know I'm going over my time, but if I could just for a moment discuss Jamie D., because I think it's important just to discuss the definition of dangerous knife and the origin of it in Jamie D. Because Jamie D. was writing, in some sense, on a clean slate, because dangerous knife is undefined. And so Jamie D. said some knives are presumptively so dangerous that they're like daggers and stilettos. I don't think a box cutter is like that. I don't think anyone really argues that. But then there's also then citing to the definition of dangerous instrument, the court in Jamie D. said, but there also could be use-based situations where possession of something that's otherwise a tool becomes a dangerous knife. And I think it's important to look at that dangerous instrument definition that Jamie D. is relying on to establish this use-based definition. Because if you look at the statutory definition of a dangerous instrument, it's an item that's used or intended to be used or threatened to be used, you know, in this way as a weapon. And in the case law regarding dangerous imminence, there's also an imminence requirement. And so in Jamie D., you had someone who had just committed a crime. He's being chased by the police. He grabs his belt. There's a knife there. He refuses to bring his hand out. So under those circumstances, he's threatening its immediate use. Now, in this case, where you're talking about, you know, I carry for protection, you're talking about a different situation. You're talking about a future use, but you're also talking about conditional use. You're saying that I may use it, you know, if the situation arises where I can lawfully use it. And also, most importantly, you're talking about a lawful use. Because when you're talking about a future prospective use of something to protect yourself, you know, it's possible to act to sort of try to act in a justifiable way and not succeed. But the goal of protecting oneself in the future is a lawful goal. And so I think it's important to go back to the root definition of a dangerous knife in Jamie D. and not read it so broadly to say that, oh, I consider it a weapon and therefore it's a dangerous knife. And just to end with one important point, to go back to one of these examples, which is that, you know, if my niece is in her apartment in Brooklyn and she hears that there's been a series of burglaries in the neighborhood, And so she takes her penknife or her X-Acto knife and puts it at her nightstand. I don't think I have to tell her that she can't do that because she might get arrested. She'll have a great defense at trial. But, you know.
What if she's trespassing in the lobby? Should you tell her then? You probably shouldn't carry a knife if you're trespassing because you might get arrested.
I think that the trespassatory aspect of this case, that the problem with relying on that is that it's just simply not connected, I think, factually, to his possession of the knife. And in that regard, it's very much like the matter of Ricci S., which is a case that Judge Fahey referred to earlier from this court. In that case, Ricci S. had a hunting knife, and he was arrested, you know, coming into a drug den. And yet the court said, not a dangerous knife, because there was no connection. He had it on him, but there was no apparent evidence that he was possessing that knife in a manner that was connected with his maybe going there to purchase drugs or whatever he was doing. So the court said, you know, that's not enough. If that's not enough, you know, then I think it can't be the case that your sort of awareness or your even like temporarily using something or even using something for protective purposes that's lawful, like the niece in the apartment who puts the X-Acto knife at the nightstand. Like the fact that she now considers it a weapon, that's far too broad a standard, and it's way too subjective and problematic to found the basis of triggering a presumption on lawful intent. And so I really urge the court to go back to Jamie D. when you're wrestling with how to define dangerous knife and use a definition that, like dangerous instrument, which it's derived from, is one that involves the use, attempted use, or threatened use in an imminent way. Because don't forget, if there's actual evidence of intent to use unlawfully, you know, then you're going to be able to make out the allegations easily. But you really shouldn't use this triggering presumption for dangerous knives lightly.
Thank you, sir.
Thank you, Your
I
Honor.
know this is unconventional, but if I could just direct Judge
sorry.
Stein to the
Excuse-
statute that she had asked for.
She's aware of it. Thank you.